Hello, everyone, and welcome to Uncivil Law. For today's case, we have a decision from the Court of Appeals from the Sixth Circuit coming out of Tennessee. This is the case of United States of America versus Rezan Toliver. In this case, Mr. Toliver was being charged with marijuana possession and trafficking. However, Mr. Toliver argues that his conviction was improper because the right to a speedy trial was denied. The Constitution provides that there must be a right to a speedy trial. And you might want to know, well, what exactly does that mean? What exactly qualifies as something speedy? Well, this case is going to help discuss that, so it's a very good review of this issue. And there's also a good dissent on this as it relates to the speedy trial question. So we're going to read this case, discuss the speedy trial issue. So let's get started with this. The government accused Rezan Toliver of participating in a nationwide marijuana distribution ring. The conspiracy funneled money and drugs between a supplier in California and a large-scale dealer in Memphis. The government believed that Toliver helped the California supplier transport marijuana and move money around. Toliver fought the charges at trial. After 4 days and several witnesses, the juries acquitted him on the marijuana conspiracy, but convicted him on the money laundering conspiracy. Toliver now appeals. He argues the district court violated the Speedy Trial Act, the evidence was not enough to convict him, and the district court erred in calculating the forfeiture amount. So first issue, the right to a speedy trial and was a given. Let's look at the facts. The Speedy Trial Act requires that the government try a criminal defendant within 70 days, with certain delays excused, of the defendant's indictment or forced court appearance, whichever comes later. If courts do not follow the Speedy Trial Act's 70-day rule, the remedy is dismissal, either with or without prejudice. Defendants also face their own requirements under the Speedy Trial Act. The Act requires defendants make a motion to dismiss on speedy trial grounds, and in a prior case, we explained that the defendant must make the motion after the deadline has passed. In other words, the proper course is to challenge the continuance on day 71 or later. So a defendant can only complain about a speedy trial violation after the violation has already occurred. And that part makes total sense to me. I mean, you can't complain about a violation of law that hasn't happened yet, right? So you have to wait to day 71 to make the argument. So that seems fair. The prior case Scheer governs here, and Toliver failed to meet the requirements. Even constructing his objection on April 26, 2018 as a motion to dismiss under the Act, his objection came too soon. The tally had not yet reached 70 days. By way of background, certain days are excluded from the count under the Speedy Trial Act. Those include days in which pretrial motions are pending and delays that further the ends of justice. When Toliver objected, 86 calendar days had passed since his initial appearance, but not all those days count. At a minimum, we'd have to exclude the 5 days while Toliver's motion for bond was pending, plus the 13 days before his April 26 hearing in which Toliver asked to be excluded in a motion to continue. So it makes sense that days that are the result of what the defendant themselves are asking for shouldn't count, right? This is the government's burden. And if the defendant is the one asking for delays, then those days don't count because it wouldn't make any sense. So that makes sense to me. Karash says, isn't speedy trial something you have to invoke before it can be claimed? No, not necessarily. It is not atypical for the defense to waive the right to speedy trial as part of the initial bond hearing or something like that. But you have a right to speedy trial unless it's waived. So you don't have to claim it. You can waive it, and there are tactical reasons you might want to do so. But no, you don't have to explicitly claim it. It's yours unless it's waived. So, yeah. The district court properly excluded that time because it served the ends of justice for Toliver to receive the extra days to decide whether to go to trial. Thus, subtracting 18 days from 86, the total number of countable days fell below 70. Because Toliver cannot meet the timing requirement, his claim of asserting a violation of speedy trial cannot prevail. Okay, kind of makes sense, right? We have to do it within 70 days, but some days may not count for some reasons, and these days don't count for various reasons that are established in our case law. So that kind of makes sense. Now, to the extent that those readings are consistent with this case law, the dissent's going to get into in a minute. But at least on the surface, seems to make sense. But the dissent of this will have some words to say about this in a minute. Tolliver argues we should unwind the jury's decision to find him guilty of conspiracy to commit money laundering. He faces an uphill battle. After all, we take the evidence in the light most favorable to the prosecution and ask whether any rational trier of fact could have found Tolliver guilty. By the way, while I'm thinking about it, in case anyone asks, why would a defendant waive their right to speedy trial? Why would that be a tactical reason? Because I just said it without explaining it, so I should probably explain it. There are two main reasons a defendant might want to do it. The first is for time on investigation on their own things. If you invoke your right to a speedy trial, then everyone has to be ready in that time interval. And if you, as a defense, have a claim of defense that's going to require expert testimony, expert reports, and so forth and so on, it may be difficult to impossible to put that all together in the time period. So you can invoke your right to the speedy trial, but you have to be ready to go. If you're not ready to go, then you might want to waive your right to speedy trial so you can have more time to put together your case if it's a complex defense and requires a lot of moving parts and so forth. Maybe you need to track down witnesses, maybe you need to get expert witnesses, maybe you need to have new studies done, maybe you have to have those studies reviewed, maybe you have to have them done a couple times. So that's reason number one, to actually build your defense. Reason number two, you might want to waive your right to a speedy trial is because time is almost always considered to be the friend of the defense. Time is always considered to be the friend of the defense because things can happen in time, right? Witnesses might die, not because of anything the defendant did, just because of, circumstance and therefore no longer available. Evidence could get lost or tainted, or such things as that. People might move out of state, become unavailable, or people might not want to testify anymore. So it's usually to the defense's advantage to stretch things out because more time goes on, recollections get worse of witnesses, so it's easier to say your memory is bad because it's been longer. The witnesses might not be available. Their stories may change over time, especially if you have any kind of prior deposition or prior statement that they made, like to the police as part of the evidence. Like most people's, if you ask someone a question today and 10 days and 100 days and 1,000 days from now, their answers are going to differ. And so you can look at those discrepancies as a method of impeaching that witness. So there's all kinds of reasons as a defense you would want to stretch out time as a tactical reason. Of course, it does mean that your guy is sitting in jail longer than he would if he's not available for bond or bail. But it's probably better than the alternative of him sitting in jail for even longer if he's convicted. If you can, through buying time, make your case better and the prosecution's case worse, which is usually how these things go, then as a lot of defense attorneys would do this. Of course, it's up to the client because they're the one who has to sit in jail. But there's a lot of tactical reasons you'd want to, both to build up your own case and to see if you can make the prosecution's case fall apart through erosion of time. So there's your reasons why you'd want to do that. So hopefully that was good clarification. The jury is the backbone of our constitutional system. As anti-federalists recognize, juries have so long been considered the surest barrier against arbitrary power and the paladin of liberty. Tolliver challenges not only the amount of evidence the government put forward against him, but also the type of evidence. So first we consider whether the government was trying to prove the right thing, then whether they put forward enough proof. As to type of evidence, Tolliver says the government did not prove money laundering, just payment for drugs. But our binding precedent makes this clear. Payment for drugs can constitute promotional money laundering. The idea is that using money gained from drug sales to buy more drugs promotes the conspiracy by allowing it to continue or grow. In a sense, the defendant reinvests the proceeds into the conspiracy, thus promoting it. It's a bit like reinvesting a stock dividend or letting it ride after a lucky gambling streak. So I kind of like this analogy, right? If you're participating in stocks and you have earnings, it's like, oh, I'm going to reinvest. So that's money laundering because you're propping up the very stock you're investing in, which if you're investing in it is really good. If what you're doing is drug smuggling, not so good, right? So the idea that you're using your own capital to reinvest it is money laundering in the circuit, and it certainly makes sense on first blush to me. And that is what happened here. The government's evidence went to whether Tolliver engaged in promotional money laundering. Indeed, our circuit has held the pragmatic example of promotional money laundering is a drug dealer using the proceeds of drug transactions to purchase additional drugs and consummate further sales. Well, that seems pretty much right on point, right? That's exactly what's happening here. So it's like, oh, the precedent says exactly what is happening here. So yeah, not going to work. That the money Tolliver allegedly moved around was income and not profits does not change things. I agree. Finally, the court is going to get into the forfeiture issue. Now, this is criminal forfeiture, not civil forfeiture, because it's as a result of a criminal case. So all the things that we have issues with civil forfeiture are not as much a problem to not a problem at all, depending on your point of view in the criminal context, right? He's been convicted of stuff actually by a jury. So the criminal conviction, and this is criminal forfeiture, doesn't raise as many flags. He's had due process, right? So let's see if they got the wrong amount of forfeiture and what the court had to say about that. When someone gets paid through money laundering, the law requires they forfeit the money laundered and any property traceable to the crime. The parties agree that Tolliver should forfeit the laundered money in his accounts, but they disagree about the district court properly including some of Tolliver's gambling winnings and a $40,000 addition based on testimony at sentencing. The government must support forfeiture by preponderance of the evidence and must show a nexus between the property and crime. Basically, the government must show that it was more likely than not that the defendant either gained the money from illegal activity or derived the money from other money or property gained from the illegal activity. So both the money you earned itself and money earned from that money. So we get both the original amount and anything you earned from it in accumulation. So if you earned $40,000 in your misdeeds and you tripled it at Vegas, well, that money was dirty in the first place, so we're going to take it all. Okay. In any case, the money must be traceable to the offense. The district court did not err in finding Tolliver's gambling winnings fell under this umbrella. Tolliver gambled hundreds of thousands of dollars but put forth no evidence he had any source of income besides the cuts he got from money laundering scheme. Indeed, Tolliver filed no tax return for the 2 years in question. The district court also considered the timing of Tolliver's gambling. He was a longtime gambler, but the amount of money he gambled skyrocketed once he joined the conspiracy. In the 5 years before his involvement in the conspiracy, he never gambled more than $23,000 a year. Yet in 2017, he gambled over 30 times that much, at $712,000. The district court did not err in deciding this made it more likely than not that Tolliver gambled with laundered money. Yeah, it's a little hard to disagree with that conclusion, right? If you're showing that you're a heavy gambler and normally gamble $23,000, which is a lot, I would think, but if that's your normal amount, and then after you join the conspiracy, it's 30 times that amount, yeah, I think it's more probable than not you're using the money laundering money to gamble. Hard to disagree with that conclusion on a preponderance of the evidence standard. So the district court did not err in adding the $40,000 based on testimony at sentencing. For these reasons, the forfeiture calculations pass muster, as does the jury verdict and the district court's trial timing. We affirm. So next, we're going to get into a concurring opinion, which I previously described earlier in this video as a dissent. That was my mistake. It's a concurring opinion, not a dissent. So he concurs in the result, but he has some things to say about how the court is interpreting the law that I think are valuable. So let's now cover the concurring opinion on this and see what he has to say and how it might inform our discussion about the right to a speedy trial. Rules are rules. In the Speedy Trial Act, Congress created a clear rule that gave parties and judges notice of rights and obligations. In doing so, Congress set forth how to get a case dismissed for violations of the Act, move for dismissal, and failure to make such a motion constitutes a waiver of the right to dismissal. The plain and simple process made the law easy to follow for both parties and district courts. Then, like a council of revision, our court intervened to edit Congress's work. So he's saying that the circuit were not good judges in merely interpreting the law, that they were modifying the law through their decision. And given the number of times the Sixth Circuit has been reversed recently, particularly as it relates to habeas law, I don't find it particularly difficult to believe that they might have modified the law here in a proper way too. So he's saying that, like a council of revision, we have tweaked Congress's analysis. Pray we don't tweak it further. In the process, we turned a clear rule into a standard, all while muddling the process. No longer need a defendant make a motion to dismiss. Instead, oral objection that does not ask the district court to dismiss the charges can sometimes be enough. In doing so, I'm not sure our court thought through the consequences. That does seem to be a bit of a persistent problem, people not thinking ahead. And even courts do it. So, it is a problem, people not thinking the likely consequences, yes. Imagine a defense wants to object to a continuance, but not request a last-minute dismissal. Why would the defendant do this? Well, maybe because he doesn't want to start over. After all, the district court may dismiss the case without prejudice. And for a detained defendant, this is not great. The government simply reindicts. And that often results in continued detainment for a defendant. So what looked like a lifeline for defendants who failed to move to dismiss may not be there at all. And that's fair. One of the reasons you would dismiss with prejudice versus without prejudice is who is making the request to dismiss. If it is the defendant making the request, that's usually without. If the government's usually with. So yeah, you might not want to ask for it because the court might do it on its own and do it with prejudice, so you don't have to go through this again. So that makes sense. Another reason that a defense attorney may not move to dismiss: the weakness of the government's case. Imagine you're on the eve of trial and the government needs a continuance to gather some evidence. Again, the defendant may wish to object to the continuance, but not move to dismiss, because, as just discussed, the consequence could be dismissal without prejudice. And now the government can do what it couldn't do before: gather evidence. Here, the lifeline turns out to be for the government. Right, so if you're already on the eve of trial and the government says, we want a continuance, and you say yes, you've given the government more time to get evidence. If you already know the government's case, which you should from Brady disclosures, because they have to tell you everything. If you as a defense lawyer think, oh, the government just doesn't have enough to convict, then saying you should have a continuance is just giving them more time to get more evidence. Why would you do that? So you as a defense lawyer would say, no, I don't want to give the continuance. And you'd also say, I don't want to move for the dismissal because I might be dismissed without prejudice. So what I want to do is make the government do it. So I want them to either do it themselves, or I want them to complete their case, which I've concluded is not sufficient, and then move to dismiss in lieu of the evidence, which would be with prejudice, because the jury trial has started, and that's when prejudice has definitely applied for double jeopardy purposes. So you wouldn't necessarily object to it on the front end. You let the government present their case. They got nothing. I got my motion to dismiss, after the government rests its case, ready to go, and let's do that. That makes total sense. With our new standard, district courts are left guessing. Is that objection a motion to dismiss or just an objection? Clarity benefits everyone, the court, the public, and criminal defendants. That's one reason, among many, that judges must follow statutory text. That's why the text, not our preferred outcome or better judgment, must always be the beginning and end of interpretation. That brings us to this case. I would affirm because Tolliver did not request dismissal, either orally in writing. But even if we imagine that he did, I agree the motion came too late, so I concur. Some reasonably spicy words there from the concurring opinion as to the court interpreting laws in ways that were not intended by Congress. And I tend to agree with the concurring opinion here. What governs is what Congress wrote, not our preferred opinion or preferred interpretation. So we've tried to figure out what Congress meant and do that, not what we want. So to the extent that he's correct, that's what the Court of Appeals has done, I would agree with him. So that is the end of the case of United States of America versus Reshan Tolliver. In this case, we learned that Mr. Tolliver was charged with money laundering and drug trafficking, and he was convicted of the money laundering charges. We also learned that he was held in jail for 86 days when the law only requires 70, and so was potentially a speedy trial violation. We learned from this that certain days don't count. And we also learned from the concurring opinion that the concurring opinion feels the Sixth Circuit has misinterpreted the law, which is not exactly a novel concept because the Sixth Circuit, especially in the last decade or so, has been getting reversed quite a lot on habeas issues. So the idea the Sixth Circuit has stretched the law here too is not exactly beyond credulity. It strikes me as very plausible. So we learned a lot about speedy trial, what the right to speedy trial is. We learned who has the right to waive speedy trial, reasons you might want to waive speedy trial, and reasons you might not want to waive speedy trial. And that is the end of this case. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.